distinguished guests, colleagues, and advocates for Indigenous people's rights. Before we begin, I acknowledge that I'm joining from the traditional custodians of the land, the Ngunnawal and Ngambri people. I pay respect to elders past and present and extend my respect to all Aboriginal and Torres Strait Islander peoples present today. On behalf of the organizer, Diplomacy Training Program, welcome you all to this special webinar on the UN Declaration on the Rights of Indigenous Peoples and the UN Permanent Forum on Indigenous Issues. I am Dr. Binota Thamai, a Kogborog speaking Jumbo Tripura Indigenous person, currently working as a research fellow on Indigenous governance at the Australian National University. I'm one of the 7 expert members of the UN Expert Mechanism on the Rights of Indigenous Peoples, known as UNDRIP, which is an advisory body of the Human Rights Council. It's an honor and privilege to moderate this webinar on the UN Declaration on the Rights of Indigenous Peoples and the UN Permanent Forum. Today, we are very honored to have 2 great speakers, Elder Les Malezer and Professor Claire Charters. Before I introduce the speaker, I'd like to remind to the participants to mute sound and turn on the camera if they are able to. The questions and comments should be made via the chat function at any time. And any links to relevant reference documents will be posted in the chat room. Finally, the webinar is being recorded, and the recording, presentations, and chat links will be shared following the webinar. Please allow me to invite our first speaker, Elder Les Malezer. Les Malezer is from the Bochola Gobi peoples in Southeast Queensland. Les is recognized in Australia and internationally for his lifetime of work to promote and defend the rights of Indigenous peoples. He played a pivotal role with Indigenous peoples representatives from around the world in the historic adoption of the UN Declaration on the Rights of Indigenous Peoples by the UN General Assembly in 2007, and gave the speech on the floor of the UN General Assembly when the declaration passed. His work was recognized in 2008 with the Australian Human Rights Award, and from 2017 to 19, he was an expert member of the UN Permanent Forum on Indigenous Issues. He has held senior roles in government, including as a former head of the Queensland Department of Aboriginal and Islander Affairs. He became the founding chairperson of the Foundation of Aboriginal and Islander Research Action, which is known as FIRA, in 1974, and was twice elected as co-chair of the National Congress of Australia's First People. His presentation will focus on the UN declarations and the right to self-determination. So I invite now Les Malezer. You have the floor.
Thank you very much, Binota, for the introduction, and hello to everyone who has joined us in this webinar. It's the 3rd webinar, as I understand, of a series. So we're talking about the declaration, and I've tailored my presentation today to provide some particular information to add to the sort of information that I've presented in earlier webinars, and also further details which will appear as the series rolls out. I won't banter too much and go straight into my presentation, and I'm going to use slides to back up my my presentation, which I hope now gives you a screen. And you can see that my email address is included at the bottom for anyone who wants to follow up with a particular question or comment. I can't guarantee a response. I am open to everybody, but it's a case of workload because I do get a number of emails per day to have to work through. So as we know, we're going to be looking at the Declaration of Indigenous Peoples. And I want to start off with just this graphic. You see myself and Claire Charters, who's also joining us in this webinar. And we're discussing with Vicky Towley Corpus, who at that time was the chair of the Permanent Forum on Indigenous Issues and has since become the Special Rapporteur on the Rights of Indigenous Peoples. And I hear that Vicky is not well at the moment, but I send out good vibes and message to Vicky that we're certainly always thinking of her and respect the work that she's done. And of course, there's Milanani Trask with Vicky, who is from the Pacific region based in Hawaii and was the first of the regional members on the Permanent Forum on Indigenous Issues. I think others might be the second after, no, I think the first before Mick Dodson was a member. So you see there basically people who have conferred continuously over the decades on matters in relation to Asia and Pacific. And I realise that our audiences are generally coming from the Asia Pacific region. So today I'm going to talk about the issues that caused us most difficulty in getting the declaration adopted. And that is particularly discussion around the right to self-determination and discussion on lands, territories and resources. These were the key elements that Indigenous peoples went forward with to the UN and, of course, refused to yield any concessions on the full right to self-determination and really strong recommendations or strong articles on lands, territories and resources. So, but it took us nearly 25 years to finally get agreement and consensus on all of these things. And of course, I believe one of the problems nowadays that we will talk about at some stage is about getting states now to meet their obligations in relation to the human rights of Indigenous peoples. And I believe that particularly centres around the right to self-determination, the reluctance to yield to that particular right, even though at the global level there is consensus by the states, the UN member states, to Indigenous peoples and the right to self-determination. That doesn't translate back to the domestic situations where states are still finding it difficult to make advances on recognition of that. And similarly with lands, territories and resources, where right to self-determination is virtually impossible to exercise unless there is a recognition of the lands, territories and resources of Indigenous peoples, because around the globe, Indigenous peoples in all situations are connected to their lands, territories and resources. And I know one of the comments I received back after the declaration was adopted in 2007 was that we didn't have the word sacred lands there in the text. And I responded by saying, well, we tried very hard to use text that denoted that importance of being sacred. But we will have a look a little bit later on at those articles dealing with lands, territories and resources. So at this point, it's right to see it's important to see the connection between the right to self-determination and also the rights to lands, territories and resources. And I'll finish off, it'll be very quickly, just making some comments about attending the Permanent Forum on Indigenous Issues. The session is going to start next week. It's a 2-week session held every year. And as the word suggests, it's a forum. So it's an opportunity for Indigenous peoples to come and speak on the things that are important to them, to the UN. And it's a listening post in many ways. But hopefully it's also active in terms of continuing to see change and see that the rights of Indigenous peoples are able to be exercised everywhere. So let me go to the Declaration, the article on the right of self-determination. I've called it Article 1 there, but that was just a typo for me. It's Article 3. And you can see the words are simple. All peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. Now, that should be clear enough for people who know what self-determination means, particularly in international law and in the UN context, because the UN Charter, which is a treaty itself signed by now with 194 members of the world, are committed to meet their obligations on the right to self-determination. And we'll come to that question of obligations. The reason that there was no yielding on this is because of the next screen. You'll see that the Covenant on Civil and Political Rights, which majority of states have signed on to, has exactly the same wording in Article 1. All peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. And similarly, the Covenant on Economic, Social, and Cultural Rights is the same Article 1 that's in there. So where there's qualifications being made nowadays by states and even by human rights legal experts in defining what Indigenous people's right to self-determination is, they're making errors if they feel that it is any different from that very same right that exists in the two treaties. So the right to self-determination of all peoples, those words, all peoples, is the same. There's no difference in whether it's Indigenous peoples or other peoples as may be defined in international law. And in the covenants, and I'm using here the Covenant on Civil and Political Rights, if we look at the third paragraph, it says the state parties to the present covenant, including those that have responsibility for the administration of non-self-governing and trust territories, shall promote the realisation of the right of self-determination and shall respect that right in conformity with the provisions of the Charter of the United Nations. So I draw on that quite a lot of weight. So even though in the Charter is talking about the administration of non-self-governing and trust territories, it is intended to apply to all peoples who currently are not self-governing and do not have the right of self-determination being acknowledged. And for Indigenous peoples, it was in 2007 when the Declaration was adopted that it basically became a consideration in international law that Indigenous peoples hold that same right. And self-determination is dealt with in the United Nations Charter in specific ways. Here we see Chapter 11 of the Charter, declaration regarding non-self-governing territories. So there's actually a declaration in the Charter which is about non-self-governing peoples in my interpretation. And it starts off strongly saying members of the UN which have assumed responsibilities for the administration of territories whose peoples have not yet attained full measures of self-government recognise the principle that the interests of the inhabitants of these territories are paramount and accept as a sacred trust the obligation to promote to the utmost within the system the well-being of the inhabitants of those territories. Right, so that leaves no doubt the fact that member states have that obligation applying it where they are aware of peoples who don't have full self-determination. And in the paragraph C, it should be paragraph B. I did a lot of typos. I had to sort of quickly hand type. It says to develop self-government, the obligation is to this end, the obligation is to develop self-government, to take due account of the political aspirations of the peoples, and to assist them in the progressive development of their free political institutions. Now, I particularly point out about that word political, because it's something that's been avoided in talking about the development of Indigenous peoples. I'll talk about social development, economic, cultural development of Indigenous peoples, but they never put the word political in. But in the articles, which we'll go back to, I'll go back to that one. The Article 1 of the Covenants of the Treaty basically says the state parties shall respect the right to peoples in self-administration of self-governing territories. So it doesn't just apply to peoples within the territory of the state, it does apply to other situations where Indigenous peoples are not enjoying the right to self-determination, or any peoples for that matter not enjoying the right of self-determination. Now, I'll just go back to in Australia, where I do my work, the Parliamentary Joint Committee on Human Rights has given a definition of self-determination. And Australia has affirmed it supports the Declaration and so on. But this committee has this convenient interpretation saying there are two aspects of the meaning of self-determination under international law. The first one is that people of a country have the right not to be subject to external domination and exploitation, and the right to determine their own political status. And that was most commonly applied in relation to colonized states. The second one, particularly important, is that groups within a country, such as those with common racial or cultural identity, particularly Indigenous people, have the right, and I think it says, I'm not sure if it says peoples, but it says people, have the right to a level of internal self-determination. So they've misconstrued to that first line, which says there are two aspects of the meaning, to saying you have one or the other, you know, and the wording that they've used is basically saying that in Australia, in particular, the Indigenous peoples have a right of internal self-determination because we have common racial or cultural identity, as if we're the only ones in a highly multicultural state that have common racial and cultural identity. So you can see how states have been resisting and finding ways to downplay what has already been determined in the international treaty and the charters. Now I better move on because I'm pretty sure I'm going to be running out of time. What do I want to see here? So I'm just showing you there a group of key people, I think roughly one from each of the regions of the world, involved at the United Nations General Assembly when the vote was going to be taken on the Declaration on the Rights of Indigenous Peoples. We were just at that point of getting the photos taken, about to go into the chamber, the General Assembly hall, to have the meeting commence and consider those issues. So let's get on to lands, territories and resources. So I'll go through these in turn, but Articles 25, 26, 27, 28, 29 and 30 are the ones to look at in relation to rights to lands, territories and resources. The first one is a general statement saying that we have the right to maintain, Indigenous peoples have the right to maintain and strengthen the distinctive spiritual relationship with their traditionally owned or otherwise occupied and used lands, territories, and so on. So in drafting, the states were reluctant to use the words own, but you'll see own comes in there. They were trying to talk about having a relationship with lands, but not actually getting down to ownership, as if the rights that are provided to property holders are not included. Article 26, which is the main body of the rights, you can see the second paragraph, first paragraph, have the rights to lands, territory which they have traditionally owned, occupied or otherwise used. Goes on to say Indigenous peoples have the right to own, use, develop and control the lands, territories, resources that they possess by reason of traditional ownership or other traditional occupation, etc. I'll just move through these because I don't want to go over it too much. And 27 talks about adjudication, that there should be a fair, independent, impartial, open and transparent process with due recognition to Indigenous peoples' laws, traditions, customs and land tenure systems to recognise and adjudicate the rights of Indigenous peoples pertaining to their lands and so on. In my experience, most people have to rely upon the state adjudicating their rights to lands and resources. This clearly challenges, it says it has to be a fair, independent, impartial, open and transparent. And it even goes on to say that at the end of that paragraph, that Indigenous peoples have the right to participate in this process. So that is being emphasised there. Article 28 talks about compensation, or the general word we use is redress. And it goes down to say redress can include restitution or just fair, equitable compensation. And it's in this paragraph 2 says compensations will take the form of lands, territories and resources equal in quality, size and legal status, or of monetary compensation or other appropriate redress. So it's not just a simple case of an exchange of monies as to what redress will cover. Article 29, the right to conservation and protection of the environment. I'm not going to go into that, but you can see that it's very comprehensive in terms of trying to be very inclusive of all the interests, and particularly in Article 30, where it talks about military activities shall not take place in the lands or territories of Indigenous peoples without being justified by relevant public interest or freely agreed with or requested by the Indigenous peoples concerned. So we know that there's a lot of military activity happening on the lands which are important to Indigenous peoples, but consultation is not occurring. Now, I don't know if Claire can signal to me, but I just want to spend what minutes I've got left talking about attending the declaration. So there's just a sign from the people that had come from the regions to represent the final adoption of the declaration. So attending the permanent forum. Now, this is designed for people attending for the first time. So, but I start off by saying it's not for beginners, so learn quickly. I'll go through these fast, but I've made this presentation available, so you should be able to get this list. You should be well into your preparation at least 3 months before the session and register in time. The permanent forum has a wide mandate, but limited time and wide diversity makes it a challenge to speak on your topic. Be prepared. It is not easy to understand and cope with the proceedings. Gain a clear understanding of the role of the permanent forum. Try being in contact with your regional representative on the permanent forum. Look for documents online well in advance and read these carefully for information that you need. Know what your goal is and check it is appropriate for the session. Each session also has a particular theme. Study the agenda to be sure of your topic and goals, and then check the program of work for the timetable. The program of work is really important because your agendas can occur on different days, and some are open, some are closed. Get advice from an experienced person on how to register and speak in this session. That's usually the biggest problem. Join group discussions for better information and build contacts. So when you're at the UN, even if you can't get your presentation presented, join in group discussions. There's a lot of information. And that's the final one. Learn as much as you can when attending the permanent forum. It's not for beginners. So thank you very much. And you can see my email address at the end there, and I'll hand you back to Benota. Thank you.
Thank you, Les, for this very comprehensive sharing your experience and also the journey for adopting the UN Declaration of Rights of Indigenous Peoples and the work you lead in the General Assembly, this declaration adoption process. Now, please allow me to invite our second speaker, Professor Claire Charters. Professor Claire Charters co-directs the Aotearoa, New Zealand Centre for Indigenous Peoples in the Law, a leading university center in Aotearoa, Aotearoa. Claire is from Ngāti Whātau Tuhare Tua Ngāpuhi Tainui. Apologize, Claire, for any wrong pronunciation. Claire is a Royal Society Rutherford Discovery Fellow, investigating constitutional transformation to realize Maori aspirations under a TTT or Waitangi, drawing on lessons from around the globe, including from North and South America, the Pacific, Asia, Africa, and also Northern Europe. I'd like to invite Claire for a few presentations on the significance of the UNDRIP and its relevance to the upcoming Permanent Forum session, when Indigenous peoples representatives around the world will look at progress, challenge, and lessons learned in implementations of the declaration.
Well, tēnā koutou katoa, ko waio ko Ngāti Whakaue te iwi, ko Claire Charters tuku ingoa, tēnā koutou katoa, ngā mihi nunui ki a koutou mā. So my name is Claire Charters, as Minota said, and I come from, as he also said, excuse me, from Ngāti Whakaue, and also actually a bunch of other tribes in the northern part of Aotearoa, New Zealand. I would also like to greet the peoples of the land here, where I'm sitting currently in Oaxaca in Mexico, which include, the Mihi peoples. So I would also like to greet the peoples of the land where you are all located around, I think, particularly the Pacific, in Australia, obviously Aotearoa and Pacific Islands. So just to make a few comments on Les's presentation, particularly to pick up on a few things that he said, and talking about especially the declaration and the interpretation of it. I think he's absolutely right, as always, that we're seeing states and potentially other treaty bodies reading down some of the obligations in the declaration, and also not implementing it. But that's part of the problem, is also this reading down the declaration requirements. And part of this also stems from, I think, that who has now the authority to interpret the declaration, and in many cases it's courts and tribunals, but basically kind of state-related bodies, and the opportunities for input are not always great. So you have to be part of litigation, for example, if you want to be interpreting how courts might approach the declaration. And just because of various rules around presentation in courts and who can present, it can be difficult to influence those interpretations. So we have to be quite savvy in hoping to make sure that declaration provisions are read up rather than down by state bodies. So yeah, and there's also a bunch of comments that I will make at the end about participating in the Permanent Forum, but absolutely endorse also everything that Les has said in that context. So I wanted to draw a little bit on implementation of the declaration, because that is also an issue that will be discussed in the coming weeks at the Permanent Forum, but is, I think, for all of us would recognise are involved with the declaration, is the biggest question now, is the so-called implementation gap and how we address it. And I want to come from the New Zealand perspective, but also from other states, because my current research looks at globally around implementation and constitutional reform. So with respect to Aotearoa, New Zealand, so just like Australia, New Zealand was one of the last states to sign on, to support the declaration, and was one of the 4 states that voted against the declaration in the General Assembly in 2007. But its support for the declaration came about largely because Australia, the US and Canada were also looking to support the declaration. So there was a bit of a snowball effect. And I don't think any of the states would have enjoyed being embarrassed by having their friends also support the declaration when they didn't. Thinking about implementation of the declaration in Aotearoa, it's been somewhat patchy, and it depends very much on who is in power. So we had in 2016, 2017, our Minister of Māori Affairs, Mr. Mahuta, say that Aotearoa will be looking to draft and then implement a national plan of action with respect to the declaration. Part of that process involved an expert report on what implementation of the declaration might look like in Aotearoa, New Zealand. That garnered, for various different reasons, also procedural reasons, a lot of pushback, especially from the more right-leaning parties. So to the extent that pushback against that report was part of billboard campaigns by those on the right. So it really caught the national attention, and not necessarily in a positive way. However, the then Labour government kept going with this work with this mahi, and authorised the drafting of a national plan of action. And what was particularly interesting, in my view, for that drafting exercise was that you had this high-level panel, I guess, or leaders, which included 5 national iwi leaders and 4 ministers of the Crown. And so they were really what is, you might call it, a governance body. And then underneath that, you had the leaders of the steering group, which included me and a relatively high-level official, and then we had a working group there. So it was a very, it was a joint endeavour, which was problematic in trying to agree what the National Plan of Action should look like, but also, I think, really important for the legitimacy of whatever that National Plan of Action might say. Unfortunately, the National Plan of Action and that work towards it was canned by actually the previous Labour government, when it thought that it might suffer in the polls by supporting the drafting of a National Plan of Action. And now we have a government that, as part of its explicit coalition agreement, talks about basically ignoring and not implementing the Declaration on the Rights of Indigenous Peoples, and does so in such as I described it, in a very brutal kind of way. It's not sensitively put or put in any nuanced way. It's that the Declaration is not important, and New Zealand won't participate, particularly around Declaration activities at the international level, and it was just not really anything important at all. In fact, a rejection of it. So that's what's happening in Aotearoa, New Zealand. And as some of you might be aware and might have heard with respect to the Treaty Principles Bill, we have a very regressive government, which is pulling back and overriding many of the gains that have, I mean, if you can call them gains, from my perspective, I don't necessarily see them that way, but pulling back a number of what has been considered positive moves by New Zealand government over the last 50 years to better realise our rights, including under the Treaty of Waitangi. So going very much backwards in Aotearoa. So that's where we're at, basically. Kind of, there was some of a movement, and now there's absolutely not. What's interesting is that it is places elsewhere. So particularly in Canada, where we've seen national federal legislation to implement the declaration, which includes the drafting also of a national plan of action, which has been done, and a requirement that all Canadian federal legislation be aligned, or reviewed and then aligned with the Declaration on the Rights of Indigenous Peoples. So that's pretty progressive. And you see that also at the provincial level, at the state level, with the British Columbia, which has also passed declaration legislation. And very interestingly, there's been a bunch of cases in the last year that seek to uphold Indigenous people's right to self-determination, and particularly interpreting the Aboriginal treaty right guarantee in the Canadian Constitution consistently with the UN Declaration on the Rights of Indigenous Peoples. So that is comparatively very progressive. So other examples of where you've seen the declaration supporting supporting Indigenous people's rights and implementing the declaration include, albeit unsuccessfully, Chile, where in about 2020 it must have been, there was or 2022, sorry, I can't quite remember, there was an incredibly progressive draft constitution drafted in which it really cemented this idea of plurinationalism into the Chilean, what was going to into the Chilean constitution. So spaces for Indigenous juridical systems, spaces for Indigenous autonomy and self-determination, and so on, and also the integration of Indigenous laws and rights into the sort of non-Indigenous areas as well. It's one of the most progressive documents that I've ever seen with respect to Indigenous people's rights. Of course, that failed, unfortunately, and didn't go through, but not only because of issues around Indigenous people's rights, which were, part of the reason, but for a bunch of other reasons as well. But it was pretty interesting as a progressive move to try and incorporate and reflect more of the Declaration and constitutional reform. Elsewhere, and I'm not going to do a global, review here. We just don't have time, and I've got a lot more to learn still. But elsewhere, including in places like Ecuador and Mexico, we've seen the direct, enforceability of the International Labour Organization on Indigenous peoples' rights, and that direct enforceability, so the courts can use, and also in Chile, where courts can rely on and apply as law the ILO convention, has been pretty significant in case law. As we also probably appreciate, the declaration is a lot more progressive than ILO Convention 169 on Indigenous and tribal peoples. However, it can be also an avenue or an opening to bring in declaration interpretation. One of the most notable reforms is the reform of last year in 2024 of Mexico's constitution with respect to Indigenous peoples. They had for some time the reference to Indigenous peoples' self-determination in the constitution, but there are a bunch of even more progressive constitutional reforms, which include the recognition of Indigenous peoples' communities or peoples as being public authorities, meaning that they receive taxpayer money from the government to self-rule. And that is a process going on at the moment to, ensure that these people's communities will receive the state funding in order to self-determine. And the other interesting thing about this is that includes almost 13,000 Indigenous people's communities that they're working through to try and do this process. And there's also a process to create a general law which will seek to implement the constitutional reforms in a more, practical way. So there'll be more specific obligations set out in that general law. And that was inspired a lot that has been inspired by the declaration to a great extent. So what I will also, just with respect to the Permanent Forum, in addition to endorsing everything that Liz has said about how to participate in there, I tend to think, and I've got to be careful saying this given the audience as well, I tend to think that the expert mechanism has now, greater authority with respect to implementation of the declaration than the Permanent Forum does. It's less well attended than the Permanent Forum, but personally I think that's, if you're really thinking to stick your teeth into trying to implement the declaration, that's where it's at. From a formal perspective, I think the advantage of New York and the Permanent Forum is that it's the best thing and the worst thing about the Permanent Forum. There's so many people there, and states are always there, that you can create some noise about a particular issue. But the mandate of the Permanent Forum is, in my view, weaker with respect to implementation. And for a bunch of reasons, including that the expert mechanism now can go into states. Permanent Forum would always sit in the UN, in New York. There's a bunch of agenda items where implementation of the I'm saying that there's a bunch of agenda items where implementation of the declaration comes up, and you'll see them in the program of work for the coming session. They include dialogue with the UNDRIP and the Special Rapporteur. They include dialogue with respect to the mandated areas of the Permanent Forum, which include human rights. And as Liz said, in relation to the particular theme of that session of the Permanent Forum, which at the moment includes implementation in this coming session. I think, rightly or wrongly, the Permanent Forum, despite the limitations of its mandate, is a place where domestic issues are raised and where Indigenous people can draw the international attention to specific issues. You have to be a bit careful because it's not formally part of the mandate, but it's in actual fact what is happening on the floor, I would say, most of the time. So as Les said, I think you have to be very well prepared and know exactly what you're going there for, and work out where you're going to make your statement and how to also, I guess, cater what you want to say into recommendations for the Permanent Forum so that you don't get gabbled, so that you have to really align your recommendations, even if you're basically complaining about a state, with whatever the Permanent Forum's agenda item is, and with the hope of that it would then, that issue would then make it into the Permanent Forum's report. The other thing that I think you can do at the Permanent Forum is you can talk, UNDRIP members are there, expert members, experts from the expert mechanism on the rights of Indigenous peoples. So Binyota, I'm not sure if you're going, but Binyota and his colleagues are often there, and you can track them down. That's a good thing to be doing. You can organise meetings with the special rapporteur. You can liaise with other Indigenous peoples, which can be really important, in drawing attention to the particular issues. I think also what you do in the room in the 2 weeks of the Permanent Forum session is really important, but it's good to follow up with Permanent Forum members outside of the Permanent Forum session itself. So make yourself known to the particular Permanent Forum members, usually from your region is a good start, and try and catch them in corridors. They're extremely busy during those couple of weeks, but if you can grab their attention and follow up with them, I think that's really important. So one other thing that the Permanent Forum's mandate is, formally at least, quite focused on influencing and advising other UN entities with respect to the Declaration and Indigenous Peoples issues. So that can be really important as well. So advising, for example, the Climate Change or Food and Agricultural Organization or the World Bank, so on, who always come to these sessions to have their work reviewed, if you like. Now, we see less of UN agencies in Australia and New Zealand because we're considered developed countries, and I think they perhaps should pay more attention to us. But that role of influencing the approach of, say, the World Bank with respect to Indigenous peoples can be really powerful in other places. And the World Bank, for example, has some standards that it has to comply with when it's doing its work around the globe. So that can be really important, particularly for Indigenous peoples from developing countries. But I do think we need, in the so-called developed world, think about ways in which we can bring UN agencies to support our right as Indigenous peoples. Finally, thinking about the Permanent Forum and its role in making change and around implementation of the Declaration through constitutional change in other countries. I would say the implementation definitely benefits from this international pressure, but I would also say that our focus, I think, for many of the people who are involved in declaration negotiations is really at home at the moment in our respective areas and trying to implement it. And I think you can see this in Australia, you can see this in Aotearoa and elsewhere, that it really requires a lot of political will from those who are in power. So trying to influence those who hold that power is really crucial. So I'll leave that there and welcome questions. Kia ora koutou.
Thank you, Claire, for your in-depth sharing. We have 15 minutes now for Q&A, so I will invite the participants to write down your questions here, and anything that is related to the UN declarations on the rights of Indigenous peoples, its implementations, if there are any good practices, or anything that is relevant to your work, and also in relation to the Permanent Forum as well. While we're waiting for the questions if there is any. I'm trying to figure out in the chat box if there are any questions already here. But I don't see any at this moment. But I have two questions for Claire and Les Malezer. This is for perhaps a little more about understanding. It's actually a great pleasure to have you both who are directly involved with the negotiation process of the UN Declaration on the Rights of Indigenous Peoples. My first question is about the self-determination, the language. If we see the International Covenant on Civil and Political Rights and the Covenant on Economic, Social, Cultural Rights, Article 1, all peoples have the right of self-determination, it is stated. But in the UNDRIP Article 3, it talks about indigenous peoples have the right to self-determination. So the difference of and to. So what this makes difference and what are challenges? And the second question is about, because this is also from your experience, if you can elaborate. The Article 30 about the militarization issue. They talk about the military activities shall take place. They mention about the public interest or otherwise freely agreed. So what does this mean when they talk about the public interest here? I mean, when you have this negotiation process, what your memory call about this? So these are two, and then there are actually the two questions came up in the chat box. Perhaps I'll go later to that.
I might just quickly lead on Article 30. That provision was there that you can't really have control over where wars occur, and it was included in there in the public interest to say that, well, if there's invasion, combat going on and so on, then the state needs to defend its borders in that situation. So it was intended to deal with situations in wartime that can't really look for the nuances of consent or agreement or anything like that. So that it didn't have any more sinister at the time of the discussion that we adopted the draft other than that. But I think the rest of the article makes it clear about, I suppose, the terms on which militarization must occur, which is with the consent of Indigenous peoples. In terms of the right of self-determination, the wording between Article 3 of the Declaration and the two treaties, the two covenants, is exactly the same in the sense of the first paragraph or the first sentence. There's no difference at all. I tried to sort of indicate that in relation to the second and third paragraphs that exist in the covenants, but doesn't exist in Article 3, that in the negotiations, they were more or less broken down into articles that followed, like the right of self-government appears in Article 4, etc. So, and that's why I made particular attention to look at each one of those second and third paragraphs in the treaties to say these apply for particular reasons. The third one, because the treaty, the United Nations Treaty requires member states to have a, sacred duty to meet their obligations to ensure self-determination. At the time, Indigenous peoples were not recognised by the UN system until basically 2007, when the identity as peoples and the rights as peoples was recognised, but that doesn't weaken the relationship between Article 3 and the two treaties. And I'll just add quickly that more recently we've been indicating to the treaty bodies, the Human Rights Committee and the Committee on Economic, Social, Cultural Rights, that they should be giving more attention specifically to Articles 1 and I think Articles 2 in their treaties to the situation of Indigenous peoples, rather than just relying upon, say, Article 27, which deals with cultural rights and that sort of stuff. So, and that is happening. There's some interesting things that is emerging now through the treaty bodies. Thank you.
Thank you, Les. Claire, you have to add some.
Kia ora. So, Vinyota, just I'll leave the Article 13 militarisation there because I think Lisa's got a better memory of that, the negotiations around that particular article than I do. But of self-determination and to self-determination, personally, I've never worried about it at all. But I do think some scholars, and I think James and I is in there, that have looked at the of self-determination versus the to self-determination and think that it is a little bit significant. But to me, maybe I'm not a good enough lawyer to really get stuck into the intricacies of the difference between of and to. But to me, I don't think it's highly relevant. And Vinyota, you might, in asking that question, you might have some thoughts yourself. I'm not sure. I would also just stress what Les just said with respect to treaty bodies, that there's been a lot of push for them to take into account Indigenous peoples' rights, particularly to self-determination. So with respect to the International Covenant on Civil and Political Rights and Covenant on Economic, Social and Cultural Rights, to interpret that right to self-determination in a way that's relevant to us as Indigenous peoples. And I agree that there's quite a lot of traction coming through both individual complaints, as you might call them, communications formally, but complaints, and also you see that in their reviews of countries. And I see that I think it's called First Peoples Program, has just released its next review, which basically has excerpts from all the treaty body jurisprudence that refer to Indigenous peoples. So you should be able to find that online. It's a really great resource, and you can see the declaration and Indigenous peoples coming through more in the work of the treaty bodies. Thank you. I do see some questions coming.
Yeah, thank you. There are questions. Well, let me read the questions here from the audience. One question comes from Jawaharlal Kaul. Are there any expert case studies which could explain the extent of protection of rights of Indigenous peoples? The second question also, can any one of the speakers shed light on the type of ownership of land owning by Indigenous people, given the fact that land is mostly acquired by government and distributed to their cohort? So there are other questions also. What are the limitations of UNDRIP in enforcing Indigenous rights at the national level? So there's there are three questions. So the last questions come from the Kevin Sheridan. So can I hand over to you, Les and Claire, to respond to these three questions?
Should I speak again first? I didn't hear the first part of the question as such, and I pretty much lost the thread now of what the questioning was about. But I just would say that interpretation of the declaration of the articles can be further developed between Indigenous peoples in the states, and that I'm really saying that we did a lot of work, over that 20-odd year period, arguing articles and looking at all different ways and so on. And it was particularly adapted to what Indigenous peoples felt were the biggest concerns that they had. It wasn't intended to cover all human rights, particularly collective rights that peoples might have, but rather to ensure that in the articles make more specific references to about the exercise of self-determination in that matter. So my my expectation is that domestic jurisprudence will develop, and if you look at what is in Article, I think it was Article 27, and also there's an article further on which is more general about adjudication of Indigenous peoples' rights. Article 40 provides for, again, that fair, impartial adjudication. So I think it's a case of clearly it's afforded the protection of self-determination, but in terms of how that is interpreted in the interests of Indigenous peoples can be, I think, considered in arbitration or adjudication of disputes between the state and Indigenous peoples. And I just wanted to add one other thing when I'm referring to things is I agree entirely with what Claire had said about the power of UNDRIP. I come to the same conclusion in a separate, when I was writing a chapter about, by being mandated to provide advice to the Human Rights Council, which is the main body or the body that basically dwells over the human rights work of the United Nations, is, I think, the best value. But don't overlook Article 42, where it says that the Permanent Forum on Indigenous Issues, so it says you bodies, including the Permanent Forum, shall promote respect for and full application of the provisions of this declaration and follow up the effectiveness of this declaration. So it is actually, and at the time, 2007, because MRET didn't exist at that time, to create power in the Permanent Forum. And I think it was in the next session in 2008 that the Permanent Forum developed a General Comment 1, which is about the declaration, more or less putting an argument that it has the effect of a treaty because, unlike declarations, it puts in there states shall do this, states shall do that, and so on, which is more the mechanics of actions that treaties are meant to invoke from states. So the Permanent Forum does have capacity, and one of the advantages I think is there, and I still think MREP is the most important place, is that it's in the headquarters. And as we were told when we were trying to get the declaration through New York in 2007, that this was the place where political decisions are made. They shouldn't be saying statements like that because it's not correct. It's not a correct statement as such, a proper statement, but it is quite clearly different area. It's more political. The people that work there in the various member state missions and so on are politically oriented, whereas it's always much better when we get member state staff coming from Geneva to New York to deal with discussions there. But otherwise, we're dealing with people who are politically oriented. And that includes the third committee, which is the subcommittee of the General Assembly dealing with human rights, humanitarian issues, where they compose their own declaration without any input from Indigenous peoples whatsoever in those meetings, and which goes on to get adopted by General Assembly. Now, I don't think anything bad or disastrous has happened because of that failure to engage Indigenous peoples properly at the New York end. But I do think the Permanent Forum, which in its General Comment 1 said that their motive is to ensure that states put into law appropriate recognition and protection of the declaration. So they've made that particular case that their job is to make member states aware of this around the world and to monitor their performance of it. Yeah, I've taken a bit of time on that one, but I hope that's a good answer for the question.
Thank you, that's clear.
I want to be super quick because I see that we're actually out of time. So on the lands, territories and resources question and about the fact that land is mostly acquired by government, etc. There's just look really closely at Article 26. So there's a very broad right to lands, territories and resources expressed in paragraph A, and then paragraph B is somewhat of a bit of a step back, arguably, which refers to the right to basically possess and own those lands which you kind of currently have. It's expressed in the present tense, which is, and so then you've also got Article 27, which refers to, for want of a better word, highly contentious, to redress for lands lost. So there's quite a lot of deep nuance in the language about present tense, past tense in those LTRs, which is basically reflective of whether Indigenous people should have rights to which we've lost to our lands. And I don't know how you lose lands, territories and resources, but nevertheless. Problems and weaknesses at the national level, I mentioned political will. I think the declaration has, like Liz says, a greater force than its status as kind of only a declaration. However, I do think that were it a treaty, it might be referred to more often. I'm not sure. And in places like Australia and New Zealand, you can't enforce any human rights or any other treaty unless it's incorporated into legislation, which is circular and goes back to the political will question. Complaint mechanisms, I mean, they include the expert mechanism, the special rapporteur, presenting statements at the permanent forum, and also the treaty body's procedures, as well as others. You know, there's procedures through the OECD, there's procedures through World Bank if that's applicable, and so on. But are they useful? I guess at the international level, it depends largely to how much you can draw on those critiques of what states are doing to create pressure to again change the political will or to seek to change laws and influence courts and other tribunals. With respect to companies and human rights, I mean, there is a generic problem there that arguably business is not covered by human rights obligations. Those obligations are held by states only under very orthodox human rights thinking. But a lot of that has changed post the Ruggie guiding principles on the, I guess, obligations on business, etc. So it's not an area that I think is completely clear, but certainly there are obligations on states to make sure companies are compliant and so on, but it's not the clearest of cut things. Yes, you can have lovely constitutional change and no effective, so a formal change in the constitution, but then no effective change on the ground. That is very much a problem, and I think that's an issue in Latin America in general with constitutional norms about their enforceability and so on. But I would suggest that maybe if you've got constitutional backing, that you've got a better chance of getting somewhere than if you don't. But yes, there can be that problem that looks really pretty, but in fact, there's not much going on in terms of rights compliance. So I'll leave that there because those are the questions I saw, and I'm very conscious that we're 5 minutes over, but thank you.
Thank you, Chair. Before I hand over to Patrick for the vote of thanks remarks, I'd like to convey my sincere gratitude to both of you for your time and for sharing your thoughts. And for the audience, I'd like to convey you a message that actually UNDRIP, as a subsidiary body of the Human Rights Council, have already did some study and also advised the Human Rights Council. Those thematic studies include the self-determination, land rights, right to participation, and all the language, culture. So these are broad issues are there. And I hope those studies and report will be very helpful to interpret in the future, actually including this implementation of the UNDRIP as well. We have a very recent study on this issue and the legal review, particularly Article 38. So I'll request to everyone to have a look at the website and also the study and report that have made. So I'd like to now offer the floor to Patrick for closing and vote of thanks remarks. Patrick.
Thank you very much, Benota. It's really just to say thank you very much to our speakers, to Benota for moderating today, to Les, and to Claire. I think the comment has been made. We're just very fortunate to have such a wealth of experience and knowledge, expertise to be shared with everybody today. And it's been an honour and privilege for DTP to host this webinar and the previous ones. And we hope that we can continue this work and to work with you. And we wish you all the best of luck in your own efforts to promote the implementation of the Declaration on the Rights of Indigenous Peoples. Good luck and go well, and hope to see you again. Thanks. Bye.